Hello and welcome to this Eversheds Sutherland PROPcast. My name's Geen. I'm a professional support lawyer to the real estate team here at Eversheds Sutherland. So our topic today is demystifying overage agreements. Now these sorts of arrangements can form a key part of commercial property deals, and they can be a way of balancing the financial modelling and the risks for both buyer and seller. And so they can be very useful in making sure that deals happen. From a seller's perspective, it allows them to competitively price the property to really draw in a good pool of potential buyers, but of course with the protection that should certain triggers take place, that they'll be able to recover a proportion of additional value that perhaps has been unlocked. For buyers, agreeing to an overage can mean they're able to secure their target property at a price point that really works for them, and they can build their plans around the fact that they may at some point have to share any increase in value. So the use of overage provides an opportunity for the parties to mold the deal to their needs and really ensure that it's viable from both buyer and seller perspectives. But of course, there are certain risks which the parties can then seek to manage and to mitigate. That's through a consideration of how the overage provisions are going to work in practice. And it's some of this that we're going to be looking at today. We're going to start this session with a very quick introduction to the world of overage. We'll then go into a bit more detail around some of the regularly encountered trigger events. We're going to be looking at the key terms that I would suggest are really worth agreeing at heads of term stage. We'll move on then to the different ways that value can be assessed and calculated for overage purposes and how that might play out in practice. And we'll then finish up by touching on some of the different ways that overage can be protected and how that needs to be considered in light of the buyer's plans for the property, but also mitigating risk for a seller. So, turning first to what is overage. Now, this is one of those elusive terms that comes up in property quite a lot, and it doesn't give all that much away. At its most basic, overage says that the seller is going to be selling the property to the buyer at an agreed price. But if after that sale goes through, the buyer does something which increases the value of that property from what was the agreed price initially, then the seller should get a share of that increase in value. Now, it starts off fairly simple, but of course, there are a myriad of different things to consider when negotiating detailed provisions around overage. And these are the sorts of things that parties often like to consider quite early on in a deal when they're negotiating heads of terms, as they can form quite an important part of that deal. Now, I mentioned earlier that these give the parties the chance to really tailor the overage provisions to their requirements. So this secures the opportunities for them both, from the seller of being able to sell the property, the buyer of able to secure that desired property. But of course, in those provisions, we look to manage risk for both sides to make sure that as time goes on, these overage provisions and the way they work really works for the parties and assists with what they want to achieve with the deal. There's one other point to note when considering overage, and that's to distinguish it from what's often called deferred consideration. Deferred consideration is something a bit different, and that would usually take the form of an agreed set payment that is to be made sometime after completion. Now, that is different from overage because, of course, overage, as we're going to see, is triggered by certain events and is usually looked at in terms of an increase in the value and the seller obtaining a share of that value. So whereas with overage, there looks at certain events which may trigger it in a contingent sort of way, but also a calculation of value and a share. With deferred consideration, it tends to be a bit more straightforward in that it will be a fixed payment at a certain time. And this can, of course, be part of the overall deal, and it plays into the idea of parties needing to structure the consideration and the payments as part of a deal in line with their business models. Now, I mentioned at the outset how we'll be looking at trigger events. And what we mean by trigger events is post-completion of the deal. So once the sale has gone through, the buyer has bought their property and the seller has sold it. After that date, what could happen in order to trigger overage becoming payable, or the parties to at least consider if it is payable? Now, three of the trigger events that we see quite commonly are disposals, sale of units, and generically planning. And I'm going to just look at each of those in turn, because behind a relatively straightforward title, there can be quite a bit of detail that can then be worked on by the parties as they negotiate the overage provisions. In terms of disposals, the most obvious form of disposal would be after the sale has gone through, if the buyer were to then sell on the freehold of the property to somebody else. Now, this would be an obvious trigger for an overage because it is looking at the buyer then passing the property, disposing of it to someone else, and that might be a point at which the original buyer and seller look at if there has been an increase in value and whether the overage provisions are engaged. But of course, everything isn't quite so straightforward. So whilst you can have that position of a freehold disposal, what you also will look at as part of discussions around overage provisions is, should lettings be caught? Now, we see a long letting, maybe a 999-year lease or something even longer, which can be tantamount to a freehold interest and can operate in a very similar way. So the parties might agree that that should also trigger the overage provisions. And that should be contrasted against perhaps shorter lettings, maybe 5, 10, 15-year lettings, where the buyer, after completion, is granting leases so that they can run the property. And those sort of lettings don't necessarily have a capital value, and so they shouldn't trigger overage. That's a position that's often reached, but is certainly one for discussion. And as you can imagine, there are plenty of points of detail to look at. For example, what the rent is of any of those leases, how long they're being granted for what uses. So there's plenty to look at there. Another point that comes up in disposals is the idea of charging arrangements. Many property owners will fund their business enterprises through granting charges to lending institutions, and there's a question and discussion to be had there around whether any charging should be subject to overage, and that's something that you would expect to pick up as part of negotiations. The final point in disposals that I would mention is one that is not so obvious because you don't see the grant necessarily of a property interest in the usual way, and that would be change of control. Often when businesses are buying properties, they may do so in the name of an SPV or other limited company that's designed specifically for that purpose. Rather than transfer the property later, what may actually happen is a corporate transaction takes place whereby the buyer sells the company which owns that property as opposed to the property itself. And this can be something else that might be picked up as part of a trigger event in overage. The next trigger event that I'll briefly discuss is sale of units. And this can come up most often in a housing development context. And what we could see here is that the deal has been struck between the buyer and the seller around the idea that perhaps the buyer is going to go away and develop a housing estate. And it will have certain projections around what the value of disposals of plots will be. The parties may have agreed at heads of terms and then carried through into the contractual documentation that should the value of plots increase above a certain level, that could be an event where overage becomes payable. So what we often see in this sort of scenario would be a situation where on the sale of a certain number of units, say 10 units, that could then be a trigger event to look at overage and to work out, is any overage payable? Now, of course, this one is slightly more complex because you're looking at an aggregate as there is a rolling overage and the number of units get sold. So it's about keeping focused on those provisions and being sure to pick up the calculations and the trigger events at the right time. The final common trigger event that I'm going to mention here is around planning. Now, this could be the application for a planning permission for development, or it could be a change of use. So the scenario that we're looking at here is where the seller has sold a property to a buyer. The buyer has then gone away and secured some sort of planning permission or permission for change of use, and that in itself might trigger overage. So that may cause the parties to then look at the property and work out, has the value increased? We'll be looking a bit later at how the assessments of value take place. But these sorts of trigger events, so ones focusing around planning, can be a bit more tricky to keep track of. And that's because you don't necessarily have the obvious impetus to look at the overage that you might get with the transfer of the freehold or the sale of numerous units. Of course, there are public records in order to check this sort of thing, but it's something to factor in around the idea of how will there be a continuing monitoring of overage and what are the obligations on the parties to share information. And we're going to be looking at a little bit of that later. We're now going to turn to some of the key terms which are really worth considering at an early stage when it comes to overage. Overage often forms an important part of a deal, but it's not necessarily the whole. It isn't necessarily built in there as the fundamental part of it, but it's something very important to consider early on. And there are a couple of key points which the parties should really discuss when they're discussing heads of terms and perhaps the inclusion of overage. And that's so that, of course, you don't get a certain way into the transaction and these very important terms haven't been agreed, so then you get into further discussions. You really don't want there to be protracted negotiations as part of any deal, but certainly on these sorts of points which could have been picked up earlier. The two which I'm going to flag here are the percentage share and the duration of overage. In terms of percentage share, there is no real standard position. And what I mean by percentage share is when the parties look at overage, what they will do as part of that exercise post-completion is they will look at what the property was sold by the seller to the buyer for originally. And then when they are coming to look at overage, so once there has been a trigger event, they will be looking at what the value of the property is at that date. And has there been a growth since that date? As part of the overage provisions in their contract, they will have agreed that should there be a growth in value, then there will be a percentage which the buyer will have to pay to the seller. So this is the idea that sometime later, due to a trigger event which is brought about by the buyer, the seller may become entitled to a further payment. And of course, when we're looking at that value, the percentage is going to be very, very important, and it needs to work for both parties. Of course, both parties will want to secure the most favorable position for their business, but it's important that they're working together to agree what is realistic and what is feasible. And that's why the percentage share discussions can take a bit of time, and they're important to carry out quite early on to make sure that there is a deal to be done. The second key term, which I'm flagging here, is duration. You do sometimes see overage provisions which are granted and they carry on for a long period of 10 or 20 years, if not longer. But often you will see shorter periods of up to 3 or 5 years. What feeds into the duration of the overage is whether the overage is to be one-off or rolling. Now, what I mean in terms of one-off and rolling is once there has been an overage trigger, is that to be the end of it? Is overage to be dealt with, paid at that point, and then the overage provisions to fall away, and so the buyer is no longer subject to them? Or is there every time there is a trigger event throughout a set period, could overage become payable? Again, this is something that's very important to look at, and there is a key point of risk mitigation in this scenario as the parties look at what the intention is for the property and the triggers events that could be coming down the line. So this is the sort of thing when the parties will take advice from their lawyers, from their valuers, from their surveyors in order to work out how this can be made to work for both sides in a way that is feasible and gives the right deal to get the transaction over the line. In terms of how long is appropriate, this is going to be very fact specific. It's going to depend on who the parties are, what their business models are, what their projections and their financial modeling is, not to mention any particular intricacies with the property itself. And that's why there's usually a strong team effort to look at what is appropriate for any particular deal. So when we think about assessing value, there are various different bits to it that we have to consider. So first we'll think about the basis on which the valuation will be carried out. Sometimes parties might decide to use Red Book principles. So that would be approaching it from the position of the Red Book being an independent objective standard, and both parties would decide to pursue on that basis. However, we often see a bespoke open market valuation provisions within an overage agreement, contract transfer, whatever it is that contains those overage provisions. And the advantage of pursuing the bespoke version and the bespoke drafting is, of course, the exercise of carrying out the open market valuation can be tailored to the particular property, to the sort of business that has been done and will be done there, to the nature of the parties and how they operate. So there is no perfect way to decide between a Red Book or bespoke provisions, but they both offer different advantages and different ways in which to carry out the exercise. Another point to consider around assessing value is one that I hinted at previously when discussing planning permissions, and that's whether any costs should be deducted from it, the increase in value before the overage percentage is applied. So the scenario that we're looking at there is where a seller has sold the land to the buyer. The buyer has then gone away, incurred costs on perhaps obtaining a planning permission for development, and the very existence of that planning permission might increase the value of the property. It's whether, when it comes to the value and the overage, those costs are taken into account. Again, this is a point for negotiation, and it may not be appropriate for all properties, but it's the sort of thing that discussions can happen around. A further point around assessing value is when you're looking at parceling up the target property, so the bit that has been sold subject to the overage, with other bits of land and property. This can often be seen in a housing development sense where perhaps one party, the buyer here, has undergone a land assembly exercise. So they've bought up different parcels of land from different landowners, but together it will form one development site. What may happen is that the land becomes worth more when combined with these other bits of land compared to if it was just a site on its own. So how that is dealt with in the documents can also be quite important. And of course, that is where the open market valuation provisions and the bespoke nature of the agreement can really be applied to work out what that land is worth and how the overage should be calculated. My next point on assessing value is around obligations to provide information. What will often happen in these sorts of scenarios is each party might consider all the evidence in front of them and whether they should instruct their own surveyors in order to help them calculate the value of the land. So you would get a land valuer involved, and we would usually recommend that that happens. But of course, if you are the seller, you may have limited information to do with the current use or permissions relating to the property. So it's important that there is an open dialogue with the other side about what sort of information will be needed when it comes to examining overage, whether any overage is payable, and if so, how much. And so catering for that in the documents with further obligations to provide information. And finally, although the parties will have considered a whole raft of scenarios and the different provisions that cater for the risks that might present themselves and the potential disagreements and trying to cover that off, sometimes things need dispute resolution procedures put in place. And that's so if one party says the land is now worth X amount and the other says it's worth Y, how do we find out where we're going to land? What we often see in overage provisions are expert determination provisions. So that would mean that if the parties cannot agree on the value of the land or the way in which the overage is interpreted or it works, then they bring in an independent expert to provide a decision and to give them certainty around that. What can sometimes happen as well is that they could decide instead to go towards arbitration. Now, this will depend whether the land is going to be used for particular uses, if it's particularly expensive land, if it's particularly complex. But whether a party chooses to go towards expert or arbitration, it's going to depend on a fact basis, and each case will be looked at separately. But that's the sort of thing where your legal advisors would usually help to discuss those options and to work out which is the best for your particular organization and which is the best in light of the transaction. we're now going to move on to consider how we protect overage. And what we're going to look at here are the different ways in which the parties may agree to provide protection to the seller so that the seller knows if overage becomes due, how that is going to be paid and how it has security for the payment of the overage that it's due. Firstly, we have the obvious contractual remedies because between the buyer and the seller, there will be a contractual link where the seller has sold the land to the buyer and the buyer has agreed to the overage provisions. So there are those basic contractual provisions, but it's something that then needs to be looked at both in terms of covenant strength and mitigating any risk around whether there will be sufficient funds in order to pay the overage, but also what happens with successors in title to the buyer. So for example, the buyer may sell on numerous times. This is quite common with commercial property where a property might move through numerous businesses, numerous group companies, or third parties. So it's important to think about how the overage is going to be protected. We've talked about contractual remedies, but also what you occasionally see is a charge arrangement imposed. And what that would see is that the buyer would grant a charge in favor of the seller, and that would give the seller remedies as a chargee should it have to enforce the obligations in the overage agreement. Another way, which is also quite common, is to use restrictions and deeds of covenant. Now, the important thing about protecting the overage can often be ensuring that it runs with the land. So it's making sure that any successors to the original buyer are equally bound by the overage provisions. So what we see around this is a restriction placed on the title, and then should there be a disposal, the restriction will prevent that registration of that disposal, requiring the successor in title to provide a deed of covenant in favour of the seller that they will comply as well with the overage provisions. And what this does is it establishes a contractual link between the buyer and the seller to ensure that if the overage is triggered by that successor, they will comply with the overage provisions. We sometimes see discussion around the use of restrictive covenants in order to protect overage, but there is a risk coming from case law which says that a restrictive covenant which is imposed in order to protect a financial payment may not be enforceable. So it's not something we see too much of, and it's one that we tend to watch out for. And finally, when considering protecting overage, it's not all about how to give the seller security and protection to retain and to be able to oblige any buyer to pay the overage, but it's also to do with making sure that the buyer is able to effectively operate the property. So in this line, what we tend to see are definitions for things like permitted disposals. And what that says is that if in certain instances, certain transactions, often it will be short-term occupational rack rent leases, they will not have to comply with the overage provisions. That's both in terms of them not necessarily being an overage trigger, but also in our restriction deed of covenant context, the tenant who is coming in to be a tenant under a rack rent lease wouldn't necessarily be required to provide a deed of covenant. Now, all of this is up for negotiation. It all depends on the positions of the parties, the type of property, the value at stake. So the parties will engage in a honest, frank dialogue around all of these points to come to a situation where they are able to best protect their positions, work within their own financial projections and modelling, but also mitigate any risks. So all of this is working together in order to achieve the deal that really works for everyone involved. That brings us to the end of this Evershed Sutherland PROPcast. Thank you for listening.